Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. We talked earlier in the week on the Supreme Court's argument on whether Colorado can throw Trump off the 2024 ballot under the 14th Amendment for engaging in insurrection on January 6, 2021. And to close the loop on that, Monet, one thing that was remarkable to me was the skeptical tenor of almost all of the questioning in the oral argument that took place on Thursday morning, including from the liberal justices. We have a couple clips here. Let's start with Justice Elena Kagan.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
And here is Justice Ketanji Brown Jackson asking whether this disqualification clause even covers the office of the presidency, which is not specifically mentioned in the 14th Amendment.
Why didn't they put the word president in the very enumerated list in Section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred, and president is not there. And so I guess that just makes me worry that maybe they weren't focusing on the president. And, for example, the fact that electors of vice president and president are there suggests that really what they thought was, if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
Monet, I came out of this argument wondering if there was, 2 votes or maybe even 1 vote on Colorado's side here, or maybe we're going to get a unanimous or close to it ruling from the Supreme Court.
Well, that's exactly the encouraging reading that I think a lot of people are coming out of that oral argument with. The unanimity of the courts would be absolutely huge on this issue because of how important it is. Obviously, we don't want to set a precedent where any state is able to disqualify a presidential candidate, because we know as soon as that floodgate is opened, it's going to become a regular occurrence across the country in every single presidential election. So for the Supreme Court to not only decide that Colorado is unable to disqualify Trump, but to do so with a united front that shows that the decision isn't something being pushed by the conservative majority would be really healthy for American politics and future presidential elections. But I think that the reading that you had isn't overly optimistic. Anyone listening to the line of questioning from the liberal justices would have to think that they are very skeptical of Colorado's case. The idea that Kagan called into question that this sort of national question could be decided by individual states is sort of a key plank of the Colorado argument that she attacked, I think, very directly and showed her skepticism of. And same thing for Justice Jackson's line of questioning. I thought that was particularly impressive. She was suggesting that not only might there be a lack of evidence for Colorado to disqualify Trump, but that presidents are actually excluded from that 14th Amendment provision in the first place. And I think that you would have a lot of liberal justices or liberal jurists who would rather preserve that power of the court to be able to weigh in on the president's eligibility. And so kind of her taking that line of questioning and suggesting that the president is actually exempted from that is something that maybe went even a little bit further than people expected the justices to go in terms of making sure that this doesn't become a recurring problem for future presidential elections. So, of course, the voting will come later, and there's still time for the justices to speak amongst themselves and study the question. But But in as far as the oral argument shows where they're leaning, it's an encouraging sign so far.
Kim, we'll give you the last word. But the other thing that struck me about the argument was just that the skeptical questions were on a whole range of issues. Does this disqualification clause even cover the presidency? Can states apply it? Does Congress need to set out some formula for what an insurrection is defined as in this context? Is the 14th Amendment's disqualification clause self-executing in that way? And there was another stumper, I thought, from Justice Gorsuch, who said, okay, your argument is that on January 6th, the president of the United States, Donald Trump, made himself ineligible to hold that office. Well, President Biden was not inaugurated until January 20th. And so was there 2 weeks where President Trump was not legitimately the president? He was a pretender. Could people go back and sue and try to overturn any actions that the executive branch took in that period? And then Justice Samuel Alito joined the pile-on and said, what about prospectively? What if you had a military officer after January 6th who decided he was going to refuse his orders because the president is not legally the president under this disqualification clause, if this is self-executing and automatically works without any intervention or finding by Congress or any court? Kim, again, I find the skepticism unanimous almost among the court, although Justice Sonia Sotomayor was a little harder to read, but I find it harder to figure out which specific grounds they are most likely to go after as they are probably ruling against Colorado.
Yeah, and I would wager that what's going to happen now is Chief Justice John Roberts is going to do a lot of canvassing and try to find the area or those areas where he can get a 9-0 decision, if that's possible. And I sure hope that that's what happens. I mean, as you have mentioned, and we've run through, there were a great deal of areas you could go on this. I thought it was really fascinating how concerned the liberal justices were about the states and the self-executing aspect of this provision. But when you back up, that shouldn't surprise people at all, in that that side of the bench tends to be more skeptical of states' rights. And you add to that the potential havoc of states in a patchwork quilt confusion here. So it could be on that. It could be on the technical questions of why the president's name wasn't specifically mentioned. But I really hope, and I've said this before, that they do get to a 9-0 decision. You know, Sotomayor was a bit quiet. Everyone's wondering about that. But it would be a very strong signal to send. First of all, to show unanimity in the court on issues like this, when everybody feels so cavalier about claiming the court is political. So to speak in one voice on this and to brush back some of the lawfaring that's going on would be good. But also just to send that signal that there are limits to this new rage of trying to litigate everything that should happen in elections in courts, and that the court isn't going to have a lot of tolerance for it.
Thank you, Kim and Monet. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back next week with another edition of Potomac Watch.